is from Supreme Court of India and who is the founder of Elder Advocates Association, Supreme Court of India. The most respected, Mr. Rana Mukherjee sir. And I think he is one of the appropriate person who is going to discuss about professional ethics. I think, sir, professional ethics is the most important aspect that everyone has to learn in the contemporary era of the advocacy. Most of us, I think, we are now not aware about the nobleness of the profession or how to give appropriate respect toward this profession. And this is one of the most important session, and we received such an eminent person for to discuss about the topic on this professional ethics or legal profession. So it gives us immense pleasure in welcoming the resource person of this session today, Mr. Rana Mukherjee sir from Supreme Court of India, and who is a senior counsel. And sir will discuss about on professional ethics. For this, I would like to invite Harini to give a brief intro about the resource.
Thank you so much, ma'am. Good morning to all the dignitaries on the dais and off the dais. It takes immense pleasure and honor in welcoming the keynote speaker for this session, Shri Rana Mukherjee, Senior Advocate, Supreme Court of India. Welcome, sir. Thank you so much for taking your time out of your busy schedule and coming. Just a brief introduction about sir. Shri Rana Mukherjee sir was born in a family of mining engineers and geologists and had his initial education in Rourkela, Odisha. He shifted for his further studies to Calcutta. He is an alumnus of St. Xavier's College, Calcutta. He got his degree in law from Calcutta University and started practice in a solicitor firm in Calcutta before shifting to Delhi. His early years of practice revolved mostly around company law and arbitrations. From 1989, he has been practicing primarily at the Honorable Supreme Court of India and at various high courts. He was designated as senior counsel at the Honorable Supreme Court of India, and his practice revolves around the interpretation of constitutional law, property, arbitration, and the insolvency code. He is also a member of the Supreme Court Legal Services Committee, apart from being in the panel of Central Government, State Government of Uttar Pradesh, and State Government of Odisha. He is also associated with Project 39A and the National Center for Promotion of Employment for Disabled People. He is a vocal supporter of increasing the representation of women in the profession as well as in the judiciary. Thank you so much, sir, for coming. I now invite sir onto the podium to deliver a lecture on the topic professional ethics. Over to you, sir.
Good afternoon to all the members sitting on the dais and young students here, and a few my friends sitting downstairs too. Let me begin by saying that, continuing from what Justice Anand Venkatesh said about that little jar, you fit in. Your mind is like a sponge. Please take in as much as you can. Don't overcram it, but take in. So the example of the sand settling with the water, then resettling the whole thing, making more space. This is a unique thing which God has given us. It can shrink, it can expand. It can do wonderful things, it can do horrible things. So that is where we have to draw that line, and that is where ethics come in. Now, before I start this topic on ethics, you see, in the current day and age, we are harboring on a very thin line, and pardon my not being able to speak in Tamil. It will be a bit difficult. I understand little words of it, but I can't converse. Ethics is something which is not a rocket science, it's a behavioral science. It's what you think. Ethics has to be read with morality, good conscience, and your heart. You see, what may be ethical for me today may not be ethical for someone tomorrow. So ethics, ethos. So before I start, like Justice Venkatesh said, this poem would have some relevance to the topic today by Nobel laureate Rabindranath Tagore, where the mind is without fear. I hope you have heard the poem. Let me read a few lines. Where the mind is without fear and the head is held high, where knowledge is free, where the world has not been broken into fragments. Please underline these words. Broken into fragments by narrow cosmetic walls where words come out from the depth of truth, part of ethics. Where timeless striving stretches in arms towards perfection, where the clear stream of reason has not lost its way. Stream of reason, again part of ethics. Into the dreary desert stand of dead habit, where the mind is led forward by thee, into ever-widening thought and action into that heaven of freedom, my father, let my country awake. And this was spoken of, this was penned down some 70 or maybe 90 years ago. It has so much of relevance even today in our profession, where the mind is held high and the mind is without fear. As a lawyer, we owe a lot of responsibility first to the society, to the client, and to the judicial dispensation system. Who are we? We are just catalysts. Someone comes and tells us of some pain, or someone tells us that someone has caused pain, and then we take up that cause for that person and then advise him or her. Okay, now, General Clauses Act says where the word he, please take it as her. So don't take it amiss if I only use the word he. So we put the best foot forward for the client and then embark upon a journey which may last from the basic Tehsildar's court to the Supreme Court, or from the basic magistrate's court to the Supreme Court. So what we do today for a client, in our best judgment, we advise them to take certain steps which may not be palatable to the other side, but will be within the boundary of ethical practice. Now, what is ethics? Ethics is a word derived from the word ethos. It's a Greek term. And from the Latin word mores means custom. Both the terms, when combined, provide a definition of how an individual chooses to interact with one another. Ethics in philosophy represents what is good for the person, for the society in general, the established nature of duties people owe themselves to one another. Now, Black's dictionary would have a meaning, but ethics cannot be compartmentalized. You cannot say that because I am doing this, the other one should also do it. It does not work that way. There's no exaction of the standard of ethics. But as a lawyer, what we have to do is, you see, like the doctors have a Hippocratic oath. They take that oath. Whether they follow it is another thing. Our Advocates Act and the Bar Council regulations assume that we take an oath of doing the best for a client who comes to you. Now, Edmund Burke, a leading British parliamentarian in the 17th century, had this to say: the law is one of the first and noblest of human sciences. Please understand, noblest of human sciences, a science which does more to quicken and invigorate the understanding than all the other parts of learning put together. So what does law do? Law enables people to come and ventilate their grievances before a forum. A judge sitting on the dais would then take a call on who's right, who's wrong. In the process, the judge may make some mistakes. It happens every time. So we get an appellate forum, a forum above that, for correction of such mistakes. Now, to the best of my knowledge, even the judge would have to fall within the boundaries of ethics. A judge is no more or no less than a lawyer who's just taking a call sitting on the bench. It is not as if the judge has a god in some. That's what the Chief Justice Chandrachud said in Calcutta, that please don't replace us as gods. We are mere human beings. We are doing what you tell us to do. As lawyers, that duty is cast upon us to project the best case for the client. Now, if you look at how the laws evolved in India, so Indian legal system started from Diwani Adalat, Sadar Adalat. Then the letters patents came where 3 high courts, chartered, which we call the chartered high courts. Madras High Court is one of them. Calcutta, Bombay and Madras. So we had 1862 when I believe the Madras High Court was set up. And the oldest high court is actually Calcutta High Court. But they all followed a general principle of practice, which is that advocates and vakils, as they were called those days, before the Advocates Act came in, would render the best possible service, be truthful to court, and not mislead the court to get a good judgment in favor of his or her client. Now, these are very easily said. In this competitive world, if a lawyer, what does a lawyer do? If you look at Section 23, Section 126, 129 of the Evidence Act, what does the lawyer do? There's a privileged communication concept. The client, what happens, let us take an example of a hardcore criminal who has committed a murder and facing investigation comes to you and confesses that I have committed the crime. Now, is it your duty to go and tell the police? Such confession is not admissible in evidence. Justice Venkatesh touched upon Section 27. It does not fall within the realm. It's only a privileged communication or knowledge that you have. You're going and telling the court, the investigation, that I know he's committed a crime, does not take the case any more forward. It is for the police to investigate and come to a conclusion that yes, he or she has committed a crime. So this is part of the privileged communication which you can be protected under 126, 129. The police cannot compel you to come and give evidence against your client. 129 is an exception to 126. There someone can go up and stand as witness. Even a lawyer can go and stand up as witness against someone who has come and said something which is helpful to the prosecution, but it's an exception. Nobody follows that because that's a protective gear which the law enables us to take. Now, if you look at the statement of Justice Marshall, American Supreme Court, he said the fundamental aid of legal ethics is to maintain the honor and dignity of law profession, to secure a spirit of friendly cooperation between the bench and the bar. This is very important, between the bench and the bar, in the promotion of the highest standards of justice, to establish honorable and fair dealings of the counsel with his clients, opponents and witnesses, to establish a spirit of brotherhood in the bar itself, and to secure that lawyer discharge the responsibility to the community altogether. So it is a multifaceted act or role that a lawyer has to do while representing a client or a person before him or her, is that you take in whatever material there is. Now, when you find if the other side is shielding something, in the CPC you have a concept of interrogatories under Order 11, where you can ask the other side to improve the case of your client when you know that he or she is hiding something from the court. So you send questionnaire, that is before the stage of cross-examination, to elicit the best information that one can get. This is also part of the ethical practice, that you are trying to put the best foot forward for your client. So interrogatories nowadays, of course, the audience and practitioners may differ. It is lost in the sands of time. People don't use because they find, again, time comes in. They feel it's a waste of time. It is not a waste of time. These are all part of ethical practice which you should adopt when you become a lawyer. Tomorrow, you see, most of you will start practicing. Some may become judges, some may come to Supreme Court, some may be in the High Court. Please keep this in mind, that ethos with good conscience and morality have to be read together. We owe a duty to society. However much competitiveness may have crept into the legal profession, we still owe it to the society that we have done our best. For example, you know that a judgment has come from the Supreme Court yesterday, yet you go and project to the High Court because the judgment is not well circulated. You project to the High Court that no, the earlier law which was prevalent is still in force. That is bad ethical practice. The court, if it comes to know, will crack down upon you. We say, as a lawyer, you have a bounden duty to come and tell the court that I'm sorry, this judgment has been overruled. Please give me some time. I'll come back with the correct judgment. No, these are all part of a compartment within which we are supposed to work. Whether you do or not is another question, because many advocates feel a shortcut method is a quick way to success. It doesn't last long. You've seen so many lawyers who've come, they come with a bang. They adopt various kinds of practices which we don't find palatable. Maybe I'm old school. Maybe Mr. Om Prakash is old school. Mr. Durasamy is old school. But the concept is that as you sow, so shall you reap. If you do good, you will get back the rewards. Not in monetary form. That is incidental. But in the form that people recognize you to be a good, truthful lawyer who will fight tooth and nail for his or her client, yet not mislead the court. This is a general practice of ethics, which I think we are fast losing in actual time, real-time practice in court. Now, the Advocates Act, the Bar Council, Section 2, Section 3, has these little regulations which have been framed. I'll just cite a few. What is conduct in court and duty to the court, as per the Bar Council regulations? Haste to be avoided and calmness to be maintained at all times. So you don't hurry. Don't force the judge to pass a judgment in haste. Haste makes waste. Then, neither the judge nor the opposite counsel should be interrupted while speaking. The counsel should not assume that the judge has prior knowledge of the case. Some judges have, they do their homework. But yet they need to be spoon-fed because many things lack. I mean, in a slew of maybe 100 cases which a judge normally handles, he may get interest in one case. He will devote some time in the evening to read that case. And in that case, he might ask a few questions which are relevant to the case. But you may still correct that judge to say, I'm sorry, but this is the point. That's part of a good ethical practice and good conduct in court. Then one should maintain eye contact with the judges while presenting the best point forward. You know, eye contact is very important. So that's why when COVID happened, we had these huge screens in court. So I told Justice Kaul, who was Chief Justice here before he moved to the Supreme Court, he was asking questions which were slightly tough for the other side, but I could not nod in appreciation. So I told him, I stood up and said, if you can remove this, we are not able to see your expression, because I will react to such expression to answer some questions even if the other side is not answering. So this is what eye contact is very important. One should shun inaccurate expressions and employ correct language while presenting the submissions. Now please get rid of this habit of saying yeah. Yeah is actually a very derogative term. Please say yes. Learn. Put it in through yourself. Learn small words which are relevant for, disposing of cases. Judges get very irritated with terms which are termed as slang today. Correct? It may be good in a coffee shop while you're walking in the library. You can talk of in short terms in SMS language, but you should not, transport that into court proceedings. Then it's an insult to the court. The court is a hallowed, it's built of brick and mortar, but we bring it to life. We breathe life into a court proceeding. Without lawyers, the judges cannot function. Without judges, the lawyers cannot function. We all think that there should be a utopian world. Everything is perfect. Everybody is doing what they are supposed to do. But because they don't do, lawyers come in. Because they don't do, lawyers project that side of either or case to the judge. And the judge then is enjoined with the duty of ensuring that his judgment is the best judgment which is available, according to his or her thinking. So we have quite a few instances of, where bad ethical practices are adopted by certain lawyers, including some senior lawyers. They are fairly famous cases. It harbors on criminal contempt, not just civil contempt. A lawyer, if you remember the famous BMW case, I'll not take the name of the senior lawyer. If you follow certain interesting cases on the website, there was a very famous BMW case, which there was a hit-and-run case in Delhi. And two senior advocates were caught trying to influence the witness of the other side. And they were caught on a sting operation on webcam. So the first argument of those senior lawyers were, no, we did not know there was a webcam. The court ruled it out. Justice Madan Lokur, heading the Delhi High Court Division Bench, he said this is absolutely bad ethical practice. You cannot do it. And that judgment will find on Manupatra. I'll make sure that this note is circulated. I'll revise it and send it. Then there was a state of Punjab versus Ram Singh in 62, where the Supreme Court held that the term misconduct, which harbors around ethical practice, includes moral turpitude. Look up this word, the meaning of moral turpitude, which is to do with morality, improper or wrongful behavior, unlawful behavior, or a forbidden act. So this forbidden act is what, if you have a truck with the other side, while you're representing the client, it is forbidden. You can't do it. Unless until both sides agree that the two lawyers will sit and discuss for a negotiated settlement. Till then, you should not pick up the phone and call anyone on the other side to say that, see, I want to do this, I want to do that, what is your document, why haven't you done this? That's not your job. Your job is to protect your client to the best of your understanding for the papers in front of you and to take a call on whether or not to argue a particular point in court. Then, one big issue now is chargeability of fees. We were just discussing in the anteroom. See, it has become a fashion today to have exorbitant fees, which people find exorbitant. Not everybody can afford to go to litigation. But there are lawyers who do. We have Legal Services Committee. I am part of the Legal Services Committee in Supreme Court. We encourage people who are below the poverty line to approach us so that we can do the cases for free. But that does not mean that everyone can afford. Anyone above the poverty line may also have difficulty in affording fees. But what does a lawyer do? You see, a lawyer, unlike earlier times, all the 3 chartered high courts had a schedule of fee for accounting purposes in the original side. But the fee, if you look at the fee there stated, even today, for accounting purposes, are abysmally low. Some 1,000 rupees, 30 rupees for a letter. Who writes a letter? They all send by speed post. Some 75 paise for a phone call. These are all part of the chargeability for costing purposes. But what does a lawyer do today? A barrister or lawyer would have to charge. Look at the infrastructure cost today. You have a library and you have, I think, 30 high courts spewing out judgments almost every second day. So, thank God for the influence of modern technology. We have these judgments at the tip of a touch of a button. We can get it. Then we can expand on that. But a lawyer still would have to maintain a decent office for clients to have confidence, to maintain a basic library of basic books, staff. So this proportionate, disproportionate fee is an area of argument. If you can't afford a lawyer, don't go to him or her. There are so many lawyers. See, tomorrow how many students are here? About 500, 600? They all will become lawyers. Some will be very successful. Some will be very successful at the taluk level. Some very successful at the district court, civil court level. So you will have a graded fee commensurate to the work you are doing. Because if you see the small causes court here, which we have also in Calcutta and Bombay, the pecuniary jurisdiction may be up to 50,000 or something. Now it may seem insignificant for someone. For a person who has to get the 50,000, it is a very important call for him or her to go to court and say, but I need the 50,000 rupees. So the court at the lower level will take 100, 500 rupees and do the case. But as you go grading up to the High Court, to the Supreme Court, what we see as projected fees of certain senior counsels, see, I am also a senior counsel. It's not that I don't charge fees. But there are fees which are very, very heavy for the common man. So the common man may not be able to approach such a senior. But what does a person do? He can still persuade a senior, if it's a noble cause, to come up and articulate that case for him. The senior may say, okay, I'll do it for 2 days. Non-stop hearing, I'll do it, I'll not charge fees. Or I'll charge basic minimum fees. There can be a given case like that. But a senior or a, let's say a junior advocate can say, sorry Baba, I'm not going to waste my time on your case and I will not do your case. But the Bar Council regulation says you cannot refuse the client. So what happens in a criminal case? Many a time the bar associations go on strike. Somebody has raped someone. The bar association assumes as if they have seen the rape having been committed. How can they take a call on behalf of all the lawyers? So then what does the court do? There's a 1898 Allahabad High Court judgment which says you have to provide free legal aid to such a person. And the state is enjoined, or the court will appoint an amicus curiae to represent such a person. So this strikes, calling of banning of advocates from appearing is also bad ethical practice. And that the bar associations as a body should never encourage. However reprehensible the cause may be, but if you don't have personal knowledge of the cause, you should not assume that you know everything. So that's one aspect again of ethical practice. Then if you look at, let me switch over to this advocate's behavior. Now, duty of client for a full and proper disclosure, for proper adjudication. The lawyer and or the advocate has fiduciary relationship with his client. It means an advocate protecting his client in the litigation. He protects the interests of his client in the litigation in the proceeding. The relationship of an advocate with his client is of a contractual nature. You know what is the contract? The Wakalatnama, which you sign, you empower the advocate to appear, is a contract. Section Order 3 of the CPC provides for how a vakil or pleader is to be appointed and how he or she can seek discharge. So many a times what happens is the client actually is not responding to the lawyer's call, no fees is being paid. At the fag end of the hearing, the lawyer comes up and says, please discharge me, I've served a notice under Order 3, please discharge me from appearing in this case anymore. The judge may refuse. Judge will say, this is only a tactics to delay the trial, I'm going to go ahead. Whether you appear or not, I don't care. The judge is well within his rights to do it. Now, is this ethical or unethical practice? It's a matter of debate. If a lawyer has done a lot of work, but courts say that you have a right to sue that person to realize your fees. You cannot exercise the right of lien by holding back his papers, original papers, because in a suit or in a criminal proceeding, the original papers are normally handed over to the client, to the advocate, for taking it forward. And many advocates will say, I am holding back your papers, pay my fees, I'll release the papers. That is bad practice. So this is, again, in a perfect society, it sounds good that you should not do this. But for example, let us assume a lawyer who's appeared for 50 times for a client, and the client suddenly comes and says, give me back my papers. What does the lawyer do? But the courts say, you go and file a suit for recovery of your fees. You can't hold a lien, exercise a lien. A lien is a right exercise that lien constitutes filing the Sale of Goods Act also, lien over goods. So you have a right to exercise your lien over certain particular goods till your money is realized. But a lawyer has been told that you can't exercise this right. This is illegal, immoral. So whatever we do, we cross and we go on in concentric circles to say that ethical, morality, moral turpitude, good behavior, good conscience. So many a times, we have this, in this right of lien, you will find in a judgment called R.D. Saxena, in New India Assurance Company versus A.K. Saxena. I don't know why Saxena is common in these judgments. But here the case is where they discuss on how lien cannot be exercised. Now, suborning the process. Suborning is trying to defeat the process of justice. That is what the BMW case on terms hold, that the actions of those two senior advocates along with their colleagues was to suborn the process of justice. That is, you defeat the process of justice by legal means. A lawyer is not supposed to do illegal acts on behalf of his client. He is only an agent. That's why you are called agent, pleaders, vakils, lawyers. You are agents of the client. So if you have that in your mind, then you are well within your rights to charge renewable fees, to say that, see, if you don't pay me fees, take back your papers and go. You can serve a notice for realization of your fees, but nothing more than that. If a client loses confidence in you, you should have that guts in you or the heart in you to give it back. But he doesn't want to continue. Don't you go to different doctors? You go to some doctor today, he gives an advice. You say, no, I'm not liking it. I'll go to some other doctor. So is it bad ethics on the part of the patient? No. If the client wants a discharge, you're well within your rights to, because he doesn't want to continue with you. Why should you force the client to be with you? You cannot give guaranteed results. Please understand this. Any advocate who says, give guaranteed results and he takes money for that should be debarred. That's my opinion. It may not be palatable to many. Another aspect is your duty to your opponent. You see, that's this part of the Bar Council regulations also. You have to, you see, we have this habit of, even if the other side is abusing you in court, you say, my learned friend. That's respect, which we show to the other side. But that's part of the court proceeding. You should never engage in a slanging match with the other side unless or until he or she becomes very aggressive, personally towards you, makes inaccurate factual statements. You have a right to interject and tell the court, I'm sorry, this is wrong. So the court might stop that person, also rebuke him or her, and say that please come back to the case, don't use personal scurrilous allegations. So you should also be fair to your opponent, and then not lose focus of your client's case. That is very important. While trying to be two goody shoes in court, you should not jeopardize the case of your client, where the client is dependent on your advice and goodwill. Then duty to colleagues also is very important. And then most important is how you treat your junior colleagues in the bar. You spent quite a few years, I think 40 years or something at the bar. Our foremost duty when a junior advocate comes, or for example, your own chamber junior comes and opposes you in a matter, you may fight tooth and nail. But please appreciate that advocate after that hearing, the first day. Tell him or her, you've done a very good job. You know, that boosts the morale of the advocate. This is all part of a good ethical practice. A junior should not be felt wanting in court, left unwanted. You know, what is this? A senior just abused me and walked away from court. Many people do it. But it's not done. you should always encourage junior advocates because they are the next generation. Like Justice Anand Venkatesh said, we are not immortal. One day we have to pack up our shoes and the shoes we left there, we are out somewhere in the burning fire. That's the reality of life. And knowledge. Again, a part of ethical practice is the knowledge you gain, you should give that knowledge to your peers. So, as a matter of fact, in my chamber, it's not bragging, but in every morning, unconnected matters, colleagues come and we discuss. In that discussion, we might throw up some case law which might be useful to one of them. Then they go hunting, look it up, they might say, oh, thank you, it was a good case. Otherwise, they say, no, it was of no use. But this is again a circle where the profession benefits. Whether you benefit or not is not important. The profession has to benefit. Because this is the last resource of any citizen to go to court and say, that's what he said. The number of cases show that people still have faith in the judicial system. Otherwise, why should they go to court? But contra is, a lawyer is also enjoined to see that matters are settled. Even if the client says no to fight it out, if you feel that the two sides, like family disputes, those matters are matters which should be settled at the threshold itself. That's why the Commercial Court Act has a very interesting section 12A, capital A, where before you embark upon a litigation, you should try for mediation. And that is a very important facet which they have introduced. So mediation, that's why I have an objection to the Arbitration Conciliation Act. Mediation is tucked away in section 85 or something, if I'm not mistaken. Mediation should have been the Mediation and Arbitration Conciliation Act. Because if conciliation is the point, then mediation has to have top priority. All international arguments, all international arbitrations first has a mediator trying to settle disputes. But we are a very litigious nation. We like fighting. For every little thing we have fights. Street side fight, we have fights with authorities, we have fights, some may be right, some may be wrong. But we raise our voice. That's part of the democratic system. While on the ethical practice, please, we should always realize that this constitution which was developed by Dr. B.R. Ambedkar and his Constituent Assembly is what is keeping us together. The beautiful way in which it has been crafted, the way it is working out. You see, we have interpretations of the Constitution every day. In that, human behavior, Article 21, Article 20, 19, 14, everything is discussed. And there, a lawyer who comes and represents a person who is claiming to have some rights under 14 or 19 or 16 or something violated, would have to adopt such practices which is commensurate with the constitutional goals. You cannot take something out of bounds and say that the Constitution provides for this, you please give me this. It doesn't happen that way. It is written in that little book, which is the most powerful book in the world. Please take this from me. Our Constitution is the most powerful book that you can find in the world. It articulates everything, right from who we are, our rights as citizens, our rights to exercise our right of vote. Of course, Supreme Court now says voting is not a fundamental right. I have my own reservations about it. Our right to do business, free speech, right to life and liberty, fundamental duties which most people forget. We always ask what the government can do for us, but not what we can do for the government. So from 32 to 33 to Article 50 is forgotten. So right to education, right to life and liberty, everything is encapsulated. And in that process, we lawyers help in reaching a just decision in court. That just decision is based on ethical practice. So we come back to this whole route of ethical practice. Now there's one very important area where we should discuss today. Legal ethics in a digital age. You see, Chief Justice Chandrachud has been articulating artificial intelligence. I have my deepest reservations about this artificial intelligence. You see, a lawyer's draft is a language which I adopt and put forward in a paper for the judges to read and understand what we are trying to say. So how is the case built up? You give a narration of facts, you say how you are wronged, and there's a crescendo to it by which a cause of action arises and you claim relief. This is a normal sequence. Now in artificial intelligence, how can you let your confidential information in the website for some third faceless party to correct your draft? Who gives them that right to correct my draft? My language may be different from Mr. Om Prakash's language, from Mr. Duraisami's language, but it is the way we communicate to the court. That communication thought process, if it's taken away from you, then what are you doing as advocates? You very well jolly well sit at home. Can the judges employ artificial intelligence to write judgments? They can only supplement by some judgments which they can find on the net. But they cannot tell the computer to please write a judgment. These are the facts. It is not done. I have my grave reservations about the Chief Justice articulating this. I'm sorry to say so. I am at liberty to so because I'm a lawyer. I can say, I can pick up issues. But he is wrong on this score. Registry work, yes. Artificial intelligence can be employed to see how many cases are pending, give data, make a data bank, but not to substitute our little brain, like I said, it's a sponge, with artificial intelligence. Because your beauty in language, for example, some may practice in Tamil while in lower courts. Your ability to communicate in Tamil, in writing, can turn a case on its head. Correct? The ability to reply to that in Tamil, in good Tamil, can destroy the case of a plaintiff or a complainant. These are important human elements which form part of ethical practice. The moment a lawyer employs artificial intelligence, that lawyer loses his right to practice. That is what my understanding is. Otherwise, why are people paying you money? It is because of your unique, noble thought that you can put in the paper for the best case for your client. So now, last bit I think is the Bar Council was called upon by the Law Minister Meghwal to say that we want to codify the professional ethics in law. But to the Bar Council's credit, they said that it can't be codified. These are human, it's unlike a doctor has to take that oath. So these are human elements. We cannot codify what is right, what is wrong. Like I said, it's not an exact science. What may be ethical for you may be unethical for somebody else. But it's for someone, a third party, to determine whether this forms part of basic ethics and ethos of a lawyer or a lawyering concept. So, before I conclude, I should say this, just two more points. Thank God for the cell phone and your ability to save information, otherwise we get lost. I spoke of behavioral ethics also, and disclose confidential communication are covered 126, 129. Yes, and also interrogatory. So, therefore, when you look at the sum and substance of the concept of ethics, it is what a normal person is supposed to do, even in normal life. That you have to be good. In a court, the duty is even more fortified by saying that you should be fair to the court, fair to the opposite counsel, fair to the cause. You know, why is it called a cause? We call cause title. That means the cause for which parties are litigating. Therefore, cause of action. So the cause has to be projected perfectly in court to the best of your ability, understanding, and then let the court decide. But in the process, don't lose track. Don't adopt unhealthy means to reach a verdict, because many times clients come and say, you see, champer test practice is also banned in India. You can't. You can't advertise also. Bar Council regulations. In USA, if you go, you will have these big hoardings of motor vehicles accidents claim, assured sum. In matrimonial cases, I've heard that Sridhan, 30% is demanded if they succeed in getting the Sridhan back. These are all part of champer test practice. Now, champerty is something which is alien to our Indian legal system, but it happens. After all, both two humans are not equal in the thought process. So you should, when you're coming into practice of law, I don't know which year students you all are, maybe third, fourth year? Final years. So you are at the threshold of embarking upon a very wonderful journey. Please understand this, leave aside ethics. This profession will teach you, if you want to learn, so many things, of so many subjects, which you could never dream of. You know, I was very bad in maths, I must confess. But now I find that I can do some maths, I can solve some problems. If you are good in maths, your logical thinking improves. That's a normal saying. But I find lawyers who are good at understanding and comprehending problems will turn out to be good lawyers. and then improve your speech. Please, if, let us say, a friend of yours, Ramaswamy, says this book is bad, don't read it. Make it a point to read that book. You should have your own value judgment. Never depend on a third party. That's what a lawyer is all about. You have to stand up for your own, you have to be ethical, you have to be true to the whole cause. Read newspapers, read books in whatever language. The more you read, the more learning you get. The more you read, the more you understand what is right, what is wrong. Now look at the Bangladesh crisis. We sitting here will say, no, this is wrong, that is right. But we don't know what is going on at the base level. No country revolts like this. Take, for example, the ongoing fight in Gaza Strip. So that's why I have this problem of lawyers coming on TV and opining on subjects. In a matter in which they are not involved. They should not come and talk of giving opinion on subjects and a case pending in court, number one. Lawyers who are involved in the case should also not come, but it will become a fashion now, people come. That is bad ethical practice. Why should you come and disclose your client's case in front of a TV? Is the TV anchor a judge? No. Number three, you join a panel discussion. You discuss, engage in discussion of evolution of laws, of how laws are to be applied. A 2,000-page judgment is delivered on a Monday morning. By 4 o'clock, legal experts are sitting on TV and discussing para 126, para 131. I was telling them, till today, Keshavananda Bharati judgment, I haven't been able to finish. It is the most confusing judgment that you can find on planet Earth. Yet the Supreme Court has subsequently interpreted it to mean what it means. Now, why should a lawyer go to the TV channel or on social media and start discussing a judgment where the judge must have spent 6 months in understanding, then penning down 126, 136 paragraphs, and the lawyer comes on TV and demolishes the judgment in 2 minutes? One will take up para 130 and say, wonderful conclusion. One will look at para 125, what nonsense is this? Why should a lawyer engage in all these activities? You are paid to work only in court. Please understand this. When you are sitting in a group of friends, do not encourage discussion about law, please. It's my humble request. And then in North, we have this saying, lawyers are liars. That means you're liars. I don't encourage this thing. I say you correct yourself. Like I say, utopian society. Society is perfect. No need for lawyers or judges. We'll be happy doing something else, maybe farming or something. But the problem is because people are not doing what they should do, or they're denying someone their rights, it is where the law kicks in. So keep these basic things in your mind. Be truthful to yourself. At the end of the day, you should look up in the mirror and say, was I good enough today? Did I do good? Again, a very utopian thought, but try and do it. Do it every day, even in your class. If you have a fight with your friend, come back and ruminate. You should be the first one to go and say sorry. That will help you elevate to a position where the lawyer will come in good stead. I think that about sums up, the ethics thing. Test is all you're doing. Your conduct will determine how ethical you are, whether you're adopting good practices, etc. Thank you so much. So I should thank the Ambedkar Law University, the Department of Law and the Madras Bar Association. I've been requested by Mr. Om Prakash quite a number of times, but somehow I could not make time. So it would be a pleasure if you all come to Delhi, come and visit the Supreme Court and the High Court. It's always a difference, if you go to the Delhi High Court also, you'll find the practice module is different from what you see in Madras High Court or the Madras District Court. So travel, go to different High Courts if you can. Go to Calcutta, go to Bombay. Karnataka High Court is closed. Go to different High Courts, understand their ethos. Every High Court has its own ethos of practice, directions, etc., etc. So develop good practice. And last and not the least, be good human beings. That's my earnest request. Money will come, money will go. Life comes, life goes. What remains is your footprint. Now you see, you have many judges who come and talk very tough with lawyers. Nobody remembers them. People who do good, behave well in court are remembered. So for lawyers. If you are good, people will remember you. After that, you are only a photograph on the wall. Thank you so much.
What should I do with my personal morality when I give my fullest to professional ethics?
Your personal morality is what? I mean, you have a right to refuse a case for valid reasons. But the Bar Council regulations say you cannot refuse the client. I find that it's a bit stretched. But as an advocate, you should have your own value judgment. If you feel that the client is misleading you, you have a right to say, see, I'm going to project the case. If you like it, otherwise take your papers back. If that is what was your question.
When my client is not misleading me, if he confesses of a murder he has committed.
So that's your choice. But you cannot go and, because you haven't seen the murder being committed. You're not a witness to it.
Yes, sir.
That is what section 126 or 129 of the Evidence Act will give you a lead on it. So.
Okay. And another one, what happens to advocates if courts decide to adopt lie detectors? Because we are in a recent Basic Act, we have adopted.
On lawyers?
No, sir, on victims and
no, that truth serum and all is still part of I think it's awaiting a constitutional bench judgment, whether you can.
Recently we have added media files to our evidence, so in future we might also add.
No, if you remember the Ajmal Kasab case or someone where they were forced on, because what happens is the courts have adopted a policy. You know, you have a mic, there's a reporter in front, and this fellow is confessing on TV. That's not admissible in evidence because there might be two gunmen standing at the back threatening that person who is not shown on TV. So it has been told that that kind of evidence is not admissible in court. So you cannot convict a person based on a confession in there's a chain which is to be linked in a criminal case, leading to motive finally. So the chain has to become, every dot has to fit in for a court to conclude on commission of an offense. So many times you see 3 courts, conviction, there's acquittal from the Supreme Court. So these are all fine. As you go around in practice, you'll get to know how to approach a case. Right? Thank you.
One question per student, okay?
Warm greetings, sir. My question is, previous decades, for 2 decades, the advocates were interpreting the law in an easy manner, I felt. But this generation, like me, are very much difficult in interpreting the laws towards the judges. Is that mean that laws in the pretext were easy, or now the generation like us are feeling difficult to make the law interpreting, or else we are lacking in advocacy skill, or the previous advocates in the decades were so enough to interpret the law, whether the law is easier over there in the pretext, or we are lacking in the advocacy skills?
I'll tell you, like I said, I've put in almost 40 years now. No interpretation of law is simple. I don't know where you got this notion from. Right from 1950, or take Privy Council, and there is one more request I should make. Study the development of law. How Privy Council came, how Supreme Court 136 jurisdiction have come, read that separately. Those are not taught in law colleges. So, your question is that whether interpretation has become difficult today. Here the problem is, we understand law, we look at judgments, we project a case to the judge hearing the matter. The judge may take a different call. So interpretation is always subjective to so many things. Unlike medicine, where there's a patient, you administer medicine, either it works or it doesn't work. Or if you don't do the necessary checks and balances, then the doctor is hauled up for negligence, correct? But in law it is very different. You cannot, there's a Judges Protection Act, you cannot attribute malice to a judge. You can only wait for his or her interpretation. That's why you have so many overturning of judgments. You see, you have 2 judges, 3 judges, 5 judges, 9 judges. So every year, you have a churning of new concepts of law. So our law is based on societal changes. The Constitution also is a static document. It's static, but you interpret it in the way society demands you to do it. So nothing is easy. Please take it from me. We also face difficulties. Our predecessors also faced difficulties during the emergency time before that. And your generation will also face difficulties in interpreting law. It's not, again, like I said, rocket science. It's all to do with human thinking and mind. Right?
So, warm greetings, sir. So, my question is not about a professional ethics, but I deem you are the perfect person to answer for my question, sir. So, the thing is, whenever the court is overruling a judgment, a particular judgment, whether the court overrule the whole of the judgment or a particular principle which is they are facing current for the current problems, sir. Because, for example, in the year of 1973, in the case Indra Sani case, the court held that the economic reservation cannot be held, and the reservation cannot be given on the basis of the poverty of the people. But in the recent case, Jagit Abhiyan case, the court given the economic reservation and overruled that case. So whether the court overruled the whole of the Indira Sawhney case or the particular principle, sir?
5 judges can never rule, 9 judges can never overrule. What they have done is they have interpreted, read into that judgment to say that amongst the first layer of, let us say, cream, if a first layer has taken advantage of reservation policy, that's the understanding of mine. I haven't read the judgment in totality. Justice Gawai clarified later on, that the next generation should then be stopped from taking any further advantage. That is where the creamy layer within a creamy layer concept has come in. Indira Sawhney stopped at creamy layer, stopped at other backward classes. But this judgment, what it does is, because every state was now trying to introduce more reservations within reservations, Justice Bela Trivedi in a dissent said that no, leave it to the decision makers. But the majority said that within the creamy layer, you cannot have another creamy layer. So you lose your right. That's what the concept is of further reservations. Whether it's right or wrong, only time will tell. Right?
So whenever they are overruling the judgment, whether they are overruling the judgment...
This is not overruling. This is interpreting.
That's not a matter. So the basic question is, whenever they are overruling a judgment, they are only overruling the particular principle or overruling the whole of the judgment, sir?
No. Factual facts they cannot overrule. Facts is what is encapsulated. It is frozen in time. What they overrule is only a concept of law. That's why when a reference is made, specific questions are to be answered by the reference court. So those questions are answered in the manner, then they send it back to the regular benches to interpret that facts of that case in line with the judgment now delivered. That's where the judicial system works. Thank you.
Good afternoon, sir. I am Sumudesh from Government Law College, Dharmapuri. As we know from the art of advocacy, the concept of professional ethics is one of the primary part in our society, particularly in the legal profession. In that concept, I have a doubt that whether the concept of ethics is a constant or is a constant one or an adaptive one. Here, the concept of controversies may arise whether the concept of ethics is a constant medium or the thing that tends to adaptive from time to time. As one of my friend stated that the interpretation of law were difficult in this modern era. Like that, whether the interpretations in various concepts, particularly in the professional ethics, were an adaptive one, or this concept were constant. Here, the concept of controversies were rising in the both, it is like two concepts of both sides. So, what is your point of view, sir?
Like I said, ethics cannot be defined. You cannot say that this is ethical, that is unethical. What we have done over ages is we have tried to understand what is good practice and morality, correct? I don't know if you have studied in some Roman Catholic school, they would have a moral science book which was taught to us. Not to take away anything from the book, it taught us how to be good human beings. As lawyers, you don't stop being good human beings. Like I said, end of the day, look at yourself in the mirror and say whether I've done good for my client and I did good for the society in court. So you cannot have a straight line method of ethics. It is your own feeling deep down that what I am doing is good and correct. The word correct has to be emphasized. So I cannot say what is ethical 10 years back will be unethical today. Unethical is always unethical. There is no two ways about it. Correct? This largely answers because I cannot then exact on what ethics is. Thank you.
Good afternoon, sir. Sir, you have mentioned that lawyers should make minimal usage of this artificial intelligence sector. So my query is, so artificial intelligence is one of the updations of this information technology sector. So in this present scenario, if we are not utilizing this particular sector completely, don't you feel that it will make our country or our legal system feel backward when compared to other legal systems of the world, sir? What's your view regarding that?
Like I said, artificial intelligence for search modules, you want to look up specific question, some catchword, you want some judgments on that. That is also artificial intelligence. You're telling someone else to look up for you. You do that. But when it comes to drafting, when you have client confidentiality with you, you cannot let that out in the open space and tell a third party who's faceless to redraft according to their whims and pleasures. It is your drafting skill. Don't let out that bit. I'm not saying take retrograde step and avoid any kind of these platforms. But for artificial intelligence to be used for drafting, etc., for judgment writing, is a very, very horrible exercise to be undertaken. That is my personal view. People may differ with me, but I have very strong views about artificial intelligence being used for drafting or for judgment writing. These two areas I have my reservations. Otherwise, you can use it for any other purpose. Can you write a love letter on using artificial intelligence? The answer is no. You got your answer.
Good afternoon, sir. Sir, we have many judgments, like hundreds of pages it runs. We have many constitutional benches. How to read these judgments? Like lengthy judgments are there. How to read? And one more question. Today we have many reporters, journals, online, everything. Back then, in your age, how you refer judgments? Because then we didn't have these equipments, isn't it?
I wanted to discuss that with Mr. Om Prakash. Earlier, we used to have a concept of noter-ups. You know, for example, we used to have those AIR judgments. There used to be some specialized people who used to come and put on pencil, overruled, relied upon, on that judgment itself by pencil. So later on, if that was overruled, they could come and rub it and put the latest. That was the way we used to search. Then the AIR manual came up with a concept of judgments followed, judgments relied upon, judgments overruled. So they used to come. Those are early 90s. So that was the only technique we had of, and the best thing which I said was discuss amongst your peers. You know, now we have judgments even from Sikkim High Court, from some court in High Court in Kerala, somewhere in Gujarat. We have it at the fingertips. It all helps in aiding your case and for the judiciary to come to a just finding. The Madras High Court may disagree with the Gujarat finding, but they'll have to, if it's a coordinate bench, so the writ of that court will lie large all over the country under Article 226(2). But that judgment may be taken exception to. The Madras High Court might say, I'm sorry, I'm not agreeable with the principle laid down. But this is what today, when you read a judgment, please make sure, don't go by the head notes. Start reading the facts first. See what is the issue before the court. Then see how they have arranged the facts to reach to a conclusion. That is how you read a judgment. You may be 1,000 pages, but everything is encapsulated in some nutshell paragraphs, which enables the court to come to a conclusion. Judgment reading is very tough. You have to understand, because you rely on one paragraph. Somebody stands up and says, oh, look at this paragraph, it's going against him. So if you don't read the judgment in entirety, never rely upon a judgment. And there is a very famous case where 100 cases were disposed of by reading the head note. Later on, it was discovered that the head note itself was wrong. All those judgments had to be overturned. It was from Calcutta. So the head note reporting in Calcutta High Court notes was wrong. So you have to read the judgment in entirety. At your age, you should do that. We may choose to look at specific paragraphs and try and cull out what is there in the judgment. But you all don't do it, for heaven's sake. Read everything, every line. You will find some line important, some phrase somewhere used by the judge very useful. Always pen it down. Correct? Thank you.
Good afternoon, sir. Whether there is any slab for fixing advocate fees? No.
It's how the advocate feels on the day of a hearing. It is a feel-good factor.
Fixing more amount of fees is against professional ethics?
There's no professional ethics is you do not charge exorbitant fees. You do not charge fees which is extortionist in nature. Like I said, if you are arguing, a senior is arguing or a junior advocate is arguing a case, first he tells the client is going to be dismissed, but the court issues notice and stay. Then you don't turn around and say, pay me more fees. Your fees is fixed at that morning. So that difference between extortion, charging more fees, which is according to, because you see, these three chartered high courts, I should give credit to them. We had a concept of fees of a council. A council will be known that, okay, so-and-so would take, let's say, 50,000 those days or 10,000. You could go and approach the council. You knew that that was the fees. If you did make him do extra work, some extra conferences, etc., they were entitled to take more fees. You cannot fix a fee. Like a doctor, you cannot fix a fee. Nor the Advocates Act predict that a fees has to be fixed for anybody.
Thank you, sir.
So, but don't charge high fees when you go up.
Okay, sir.
Do it gradually.
Thank you, sir. Thank you so much. So, I think we
came to know about at least something know about the professional ethics. And I think you will not disrespect the profession what you are going to get into it. So first foremost, how to handle the robes, how to wear the neck collar band from that onwards. So that from this, we have learnt a lot from our senior resource person who is also giving a practical version about this professional ethics. To give a vote of thanks, I request Harini to take over the mic.
Thank you so much, sir, for such an insightful session. I think most of the audience here, we belong to our penultimate and the ultimate year of law school. And just before enrolling in the bar, getting to know about professional ethics, I think each one of us here are going to take the nuances into our professional lives. Thank you so much, sir, for coming all the way from Delhi just for addressing us. It was an honor and pleasure hearing from you. And we are very sure to incorporate each and everything we learned today into our professional lives. Thank you. Yes, sir. Definitely, sir. We'll do that. Thank you, sir.